statement. This is to advise the general public that in compliance with Chapter 231 of the Public Laws of 1975, entitled Senator Bar M. Bear Open Public Meeting Act, New Jersey Casino Control Commission on December 10th, 2025, filed with the Secretary of State at the State House in Trenton an annual meeting schedule. On December 10th, 2025, copies were mailed to subscribers. The use of cell phones in the public meeting room while the commission is in session is prohibited. Any member of the public who wishes to address the commission will be given the opportunity to do so before the commission adjourns for the day. Please stand for the Pledge of Allegiance.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Welcome everyone who is joining us in person and remotely today. Meeting participants who wish to do so can continue to address the Commission through remote technology. We are permitting in-person participation and the public meeting room is therefore open. We will, however, continue to stream our public meetings. The public is able to listen through access provided on the Commission's website as well as through our YouTube channel. We will accept public comments via email. Public comments can be sent to public.comments@ccc.nj.gov beginning now. I will repeat that. Public comments can be sent to public.comments@ccc.nj.gov beginning now and any time throughout the meeting, ending at the time of adjournment. This meeting is being transcribed as well as recorded, and minutes will be available on our website in due course. To meeting participant callers, I ask that you follow the instructions provided with the web link or audio call-in code and place your phones on mute until your matter is called. Also, when your matter is called, please turn on your camera and identify yourself before speaking. Thank you.
Please answer when I call your name for the roll, please. Commissioner Formica?
Here.
Commissioner Molyneux?
Present.
And Chairman Pelosi?
Present.
Matters discussed in closed session this morning included review of employee key license application matters. The first item on the agenda for your consideration is the ratification of the minutes of the January 14, 2026 public meeting.
Are there any questions for council or corrections?
No.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I move to ratify the minutes of the January 14th, 2026 meeting.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
Sir.
No.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
Item number 2 is the annual election of the vice chair.
Is there a motion?
Yes, sir, Mr. Chairman, I do have a motion. It's come to my attention that Section 54B of the Casino Control Act mandates that the commission shall elect annually by a majority of the full commission one of its members, other than the chair, to serve as vice chair for the ensuing year. As we all know, in August of 2025, Vice Chair Lisa Cooper retired. I took her place as commissioner, leaving our body with no vice chair. As we are in need of a vice chair by statute, it's my honor and privilege to move for the majority of the commission to elect Commissioner Joyce Molyneux as vice chairperson. Before I formally do that, if you'll allow me, just a few words. Even though Commissioner Molyneux treated me like an annoying piece of office furniture for the first month I was here, I eventually wore her down with my charm when we got to know each other. And I'm so glad we did, because personally, I find her to be a warm and kind human being with a great sense of humor. But most impressively for me, she has a genuine desire to help others, whether it be here at the commission or in her community, where I know she is an active and engaged citizen. Professionally, in the 5 months I've worked with Commissioner Molyneux, she's taught me quite a bit about my role. Listening to her speak, listening to her ask questions, listening to her insights. Both in closed session and during the public hearing, she has educated me on how to conduct myself as a commissioner, what questions need to be asked, what issues need attention. On more than one occasion, I sat there thinking to myself, why didn't I think of that? And for a guy who thinks he's the smartest person in the world, that's really saying something. Suffice to say, I've grown to greatly admire and respect Commissioner Molyneux on both a personal and professional level. And Mr. Chairman, that is why it gives me such great pleasure to make a motion to elect her as Vice Chairperson of the New Jersey Casino Control Commission.
Well said there,
Thank you,
Commissioner.
sir. Thank
I will second that motion. Is there any further discussion?
No, sir.
Hearing none, all in favor say aye.
Aye.
Aye. Opposed? Ayes have it. Congratulations, Vice Chair.
Thank you. To my colleague, I'm glad something has rubbed off on you. I find you to be a decent colleague
Thank
and capable of your title that you hold. And I appreciate all the good things you have said about me that are true.
you.
Thank you.
Congratulations.
Congratulations.
Item number 3 are applications for initial casino key employee licenses. They include Anna L. Contreras Oraco, Jody L. Hendry, also known as Jody L. Eichler, Michael R. Reynolds, and Jared B. Schwartz. With respect to Anna L. Contreras Oraco and Jared B. Schwartz, those 2 items have been reviewed by the division as well as commission staff with a recommendation that their initial casino key employee license applications be granted.
Are there any questions regarding any of these matters?
No, sir.
No,
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I have reviewed the memo of Assistant Director Ealer, the division's reports, and I move to grant the 2 initial casino key employee licenses for Anna Contreras Rocco and Jared B. Schwartz.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, all in favor say aye.
Aye.
Aye. Opposed? Ayes have it.
With respect to Jody L. Hendry, also known as Jody L. Eichler, and Michael R. Reynolds, objections have been raised by the division. Commission staff concurs and recommend that those 2 initial casino key employee license applications be remanded to the contested case process.
Are there any questions regarding any of these matters?
No.
No, sir.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, I reviewed the memo of Assistant Director Ealer, the division's reports in this matter, and I move to remand for a hearing the 2 initial casino key employee license applications for Jody Hendry and Michael R. Reynolds.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
Hearing none, all in favor say aye.
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 Opposed? Ayes have it.
Item number 4 are applications for resubmitted casino key employee licenses and/or for qualification. They include Vincent A. Alfieri Sr., Brian S. Barnett, Rebecca L. Butler Nesbitt, also known as Rebecca L. Butler, Rebecca L. Nesbitt, Naja Corsi, also known as Naja J. Bigelow, Christine Fable, also known as Christine Dwyer, William M. Fritz, also known as Bill M. Fritz, Marshawn X. Glass, Alexis A. Gonzalez, John E. Happersett, Patrick D. Martin, Joseph L. Melchioni Jr., Christine M. Pacifico, also known as Christine M. Ross, Hong D. Pham, Edmund J. Quatman Jr., Nathaniel T. Ross Sr., Jeffrey G. Solanas, Karina Silva, also known as Karina Chirinos, and Karina Hernandez, Rakeem D. Stewart, Edward A. Taylor, William H. Wentz III, and Kathleen L. Wilkins. There are several different categories of action requested with respect to item number 4. The first requested action is to consider the applications of Mr. Barnett, Ms. Corsi, Mr. Fable, Mr. Glass, Ms. Gonzalez, Mr. Haberset, Mr. Malchione Jr., Mr. Pham, Mr. Ross Sr., Mr. Solanas, Ms. Silva, Mr. Wentz III, and Ms. Wilkins. 13 resubmissions have been reviewed by the division and commission staff with a recommendation that they be granted.
Are there any questions regarding any of these matters?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. With regard to the last 13 names that General Counsel just noted, and after reviewing the memo of Assistant Director Ealer, the memo and reports of the division, I move to grant the 13 resubmitted casino key employee license as read by General Counsel last.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
With respect to Christine M. Pacifico, that action also includes a request for a multi-casino endorsement to cover Caesars, Harrah's, and Tropicana. Her resubmission application has been also reviewed by the division and commission staff with a recommendation that it be granted with the requested MCE endorsement.
Are there any questions regarding this matter?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, reviewed the memo of Assistant Director Ealer, the division's reports and/or memo, and I move at this time to grant the resubmission application of Christine M. Pacifico for a casino key employee license with a multi-casino endorsement, and that's pursuant to NJSA 5:12-91.1.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
With respect to Rebecca Butler Nesbitt and Rakeem D. Stewart, those matters have been reviewed, and the division has raised objection. Commission staff concurs, and we recommend that those two matters be remanded to the contested case process.
Are there any questions regarding these matters?
sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, reviewed the memo of Assistant Director Ealer, the division's reports and/or memos, and at this time I move for a hearing. The two remand for a hearing, the two resubmitted casino key employee license applications of Rebecca L. Butler Nesbitt and Rakeem Stewart.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No,
No.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
The remaining actions require a roll call vote. The first is Vincent A. Alfieri Sr. for resubmission and continued qualification to serve as Vice President of Table Games for AC Ocean Walk LLC. No objection has been raised, and staff recommends that his resubmission and continued qualification request be granted.
Are there any questions regarding this matter?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. After reviewing the memo of Assistant Director Ealer and the division's reports, I move to grant the resubmitted key license and qualification of Vincent A. Alfieri Sr.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, roll call vote.
Commissioner Formica?
Yes.
Vice Chair Molyneux?
Yes.
Chairman Pelosi?
Yes.
William M. Fritz, also known as Bill M. Fritz, resubmission application and continued qualification as Director of Food and Beverage for Boardwalk Regency Corporation, LLC, DBA Caesars Atlantic City. Again, no objection has been raised, and it is recommended that his resubmission application and continued qualification be granted.
Are there any questions for council on this matter?
No, sir.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, I reviewed the memo of Assistant Director Ealer, the division's memo and/or reports. At this time, I make a motion to grant the resubmitted key license and qualification of William M. Fritz.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, roll call vote?
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Patrick D. Martin, again, resubmission application and continued qualification, as well as waiver of residency to continue to serve as Vice President, Regional Compliance for MGM Resorts International. No objection has been raised, and Commission staff recommends that the resubmission application, continued qualification, and waiver of residency requests be granted.
Are there any questions for council on this matter?
No, sir.
No.
Hearing none, is there a motion?
Yes, Mr. Chairman, thank you. Again, I reviewed the memo of Assistant Director Ealer, the division's reports. At this time, I move to grant the resubmitted key license and qualification and waive the residency requirement as provided in NJSA 5:12-89B with regard to Patrick D. Martin.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
Yes, sir.
Roll call vote?
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Edmund L. Quatman Jr., again, resubmitted key license application and continued qualification, also waiver of residency, to continue to serve as Executive Vice President and Chief Legal Officer for Caesars Entertainment, Inc. Again, no objection has been raised, and it is recommended that the requested relief be granted.
Are there any questions for council on this matter?
No, sir.
Hearing
No.
none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, after reviewing the memo of Assistant Director Ealer, the division's reports, I move at this time to grant the resubmitted key license and qualification and waive the residency requirement as provided for in NJSA 5:12-89B of Edmund L. Quatman Jr. to serve as Executive Vice President and Chief Legal Officer for Caesars.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, roll call vote?
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Last one, Edward A. Taylor, again, resubmitted key license application and continued qualification to serve as Vice President of Casino Marketing for Harrah's Resorts Atlantic City, doing business as Harrah's Atlantic City. No objection has been raised, and it is recommended that you grant the resubmitted key license and continued qualification of Mr. Taylor.
Are there any questions for council on this matter?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, I reviewed the memo of Assistant Director Ealer, the division's reports, and at this time, I move to grant the resubmitted key license and qualification of Edward A. Taylor.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, roll call vote?
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Item number 5 are approvals through delegation of authority between January 1, 2025 and January 31, 2026 pursuant to, January 1, 2026 through January 31, 2026 pursuant to resolution number 22011211B. Manager Harry Givas will review those matters with you. However, no action is required.
Thank you. Good morning, Chairman and Commissioners.
Morning.
For the record, I'm Harry Jeevis, Manager of the Commission's Licensing and Financial Evaluation Unit. Between January 1st and January 31st, the staff of the Commission's Regulatory Affairs Division granted the following approvals via its delegated authority. On January 6th, temporary casino key employee licenses were granted to Sabrina R. Kottman for a sportsbook supervisor position at Tropicana. and to Chris D. Rodriguez for a dual-rate security supervisor/shift manager position at Harrah's. On January 15th, a temporary casino key employee license was granted to Don P. Gwen for a director of cage operations position at Caesars. On January 27th, a temporary casino key employee license was granted to Amanda L. Jadeo, also known as Lakshmi Jadeo, for a slot performance manager position at Bally's. And on January 29th, temporary casino key employee licenses were granted to Amir H. Muhammad for a poker shift manager position at Borgata, and to Maria L. Pachowski, also known as Maria L. Alberts or Maria L. Samolowicz, for a dual-rate casino game supervisor/assistant casino shift manager position at Harrah's. This memorializes the approvals that were granted by the Commission's Division of Regulatory Affairs via its delegated authority during this period. No further Commission action is required. Thank you.
Thank you.
Item number 6 for your consideration are requests for inactivation of casino key employee licenses. Again, our manager, Harry Davis, will review those matters with you.
Thank you. In lieu of filing a casino key employee license review application, Rosemary A. Cook, also known as Rosemary A. Lynn or Rosemary A. Muschella, Andrew J. Dicieri, Lynette A. Holcomb, Francis A. Ianello, Barry J. Lubin, Karen J. Quay, also known as Karen J. Klein or Karen J. Klein Workey, and James Weatherford have requested to be placed on the Casino Key Employee License Approved Inactive List. If the requests are granted, these individuals may remain on the approved inactive list for a period of up to 5 years. Commission staff has reviewed the requests and recommends that you grant the requested relief.
Are there any questions regarding any of these matters?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. At this time, I move to grant the requested relief in order that the 7 casino key employee licenses as listed by Mr. Gibis be inactivated.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, all in favor say aye.
Aye.
Opposed, ayes have it.
Item number 7 are your consideration of the lapsing of certain casino key employee licenses. Again, we have manager Harry Davis to review it with you.
Thank you. For your consideration is the lapsing of the casino key employee licenses of the following individuals for failure to file a casino key employee license review application or to request to be placed on the casino key employee license approved inactive list. Bhupendra G. Davi, Stephen T. Lanning, Marjorie L. Tomasic, also known as Marjorie L. Duncan, Louis J. Titaro. In each case, the due date for filing a casino key employee license is passed. Based on staff's review, we recommend that the casino key employee licenses of the noted individuals be deemed to have lapsed.
Are there any questions regarding any of these matters?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. At this time, I move to find that the 4 casino key employee licenses lapsed pursuant to NJAC 19:41A-6.1F of the regulations.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
Sir.
Hearing none, all in favor say aye.
Aye.
Aye. Opposed, ayes have it.
Thank you.
Item number 8 is consideration of the initial application of Ryan Peters for a casino key employee license. That is docket number 250200CK. We have Senior Counsel Pipinelli here to review that action with you.
Good morning, Chairman and Commissioners. Teresa Pimpinelli, Senior Counsel, appearing for the Commission. For your consideration is a stipulation of settlement for the initial application of Ryan Peters for his casino key employee license. If approved, Mr. Peters will be licensed through February of 2031. You have staff's memo and recommendation for this matter. Mr. Peters was notified of today's proceedings. I would ask counsel for the division to enter their appearance and proceed.
Good morning, Chairman and Commissioners. Jocelyn Fedowitz, Deputy Attorney General, on behalf of the Division of Gaming Enforcement. The division has something further on this matter and respectfully requests that the stipulation be approved as submitted. Thank you.
And for the record, the applicant is not present.
Correct.
Are there any questions for counsel?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I have reviewed the memorandum of Senior Counsel Pimpinelli, the division's reports, the proposed stipulation, and at this time I approve I move to approve the stipulation of settlement between the division and the applicant to grant the initial application of Ryan Peters for a casino key employee license, subject to compliance with the terms and conditions as provided for in the stipulation.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
Thank you. Item number 9 is consideration of the initial application of Dazahona A. Moses for a casino key employee license. That is docket number 250163CK. Again, we have Senior Counsel Pimpinelli to address that matter with you.
Chairman and Commissioners, Teresa Pimpinelli appearing again for the commission. For your consideration is a stipulation of settlement for the initial application of Dazana Moses for her casino key employee license. If approved, Ms. Moses will be licensed through February of 2031. You have staff's memo and recommendation for this matter. Ms. Moses was notified of today's proceedings. I would ask counsel for the division to enter their appearance and proceed.
Chairman and Commissioners, Jocelyn Fedowitz, Deputy Attorney General, on behalf of the Division of Gaming Enforcement. The division has nothing further on this matter and respectfully requests that the stipulation be approved as submitted. Thank you.
Again, for the record, the applicant is not present.
Correct.
Are there any questions for council?
No.
No, sir.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, I've reviewed the memorandum of Senior Counsel Pimpinelli, the division's reports in this matter, the stipulation executed, and I move to approve the stipulation of settlement between the division and the applicant to grant the initial application of Dazhona Moses for a casino key employee license, subject to compliance with the terms and conditions for as provided in the stipulation.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
Item number 10 is consideration of the initial application of Courtney Boone for a casino key employee license. That is docket number 250192CK. Again, we have Senior Counsel Pimpinelli to address it.
Chairman and Commissioners, Teresa Pimpinelli, Senior Counsel, appearing for the commission. For your consideration is the initial application of Courtney Boone for a casino key employee license. You have staff's memo and recommendation for this matter. Ms. Boone was notified of today's proceedings. Again, I'd ask counsel for the division to enter their appearance and proceed.
Chairman and Commissioners, Jocelyn Fedowitz, Deputy Attorney General, on behalf of the Division of Gaming Enforcement. On October 31st, 2025, the division filed a letter report recommending that the application of Courtney Boone for casino key employee licensure be denied pursuant to sections 80B, 80D, 89B1, and 89B2 of the Casino Control Act. Subsequently, the commission at its December 10th, 2025 meeting remanded the matter to the contested case process. As advised by the commission, Courtney Boone failed to submit the requisite hearing request form and comply with the contested case process. Therefore, based on the applicant's non-responsiveness and failure to comply with the contested case process, as well as the issues raised in the division's report, the division requests that Courtney Boone's application for casino key employee licensure be denied. Thank you.
Again, for the record, the applicant is not here.
Correct.
Yeah. Are there any questions for council on this matter?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. Again, I reviewed the memorandum of Senior Counsel Pimpinelli, which detailed her efforts to get in touch with Ms. Boone to complete the process, but to no avail. Also reviewed the division's reports, and at this time, I move to find Courtney Boone disqualified pursuant to NJSA 5:12-80B and D, NJSA 5:12-86, NJSA 5:12-89, and deny her application for a casino key employee license.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
Item number 11 is consideration of the initial decision in the matter of the appeal of J.M. for removal from the self-exclusion list. That is docket number 250152AP. Again, Senior Counsel Pimpinelli will guide you through that matter.
Chairman and Commissioners, Teresa Pimpinelli, Senior Counsel, appearing for the commission. For your consideration is the December 31, 2025 initial decision of hearing examiner Formica in this matter. This matter is an appeal of the division's September 12, 2025 final agency action denying JM's request to be removed from the self-exclusion list prior to the expiration of the term for which they enrolled. After considering all the available evidence, hearing examiner Formica found that appellant failed to demonstrate they were improperly placed on the self-exclusion list. You have the complete record in this matter, all of which is subject to the applicable confidentiality and privacy requirements. Appellant was notified of today's meeting. I would ask the division to enter their appearance and proceed, and just again respectfully remind all parties that appellant's identity is confidential.
Good morning. My name is Aaron Reed, Deputy Attorney General for the Division of Gaming Enforcement. The Commission issued an initial decision on December 31st, 2025. The Division submitted a clarification on January 13th, 2026. The Division requests that the Commission adopt the initial decision rendered on December 31st, denying appellant's request for early removal from the self-exclusion list.
Any questions for counsel?
No, I'm wondering, sir, is JM present here?
No.
He's not here.
He didn't come. Okay.
Okay. No, sir, I don't have questions.
No questions then?
No, sir.
Okay. Again, for the record, JM is not here telephonically?
Correct.
Yeah, okay. Is there a motion?
Yes, sir, thank you, Mr. Chairman. I would like to make a motion, but with your permission, I feel compelled to first place some things on the record with regard to what Mr. Reed said, specifically the subsequent correspondence and emails about clarification. So let me first read the statement of the case and procedural history as it appears in the initial decision. I'll read it verbatim. On or about January 8th, 2025, JM placed himself on the New Jersey self-exclusion list through the BetMGM LLC online gaming platform for a one-year period. Appellant subsequently contacted the Division of Gaming Enforcement to seek removal. By letter dated September 12, 2025, the division advised appellant that after conducting its investigation, the division had determined that appellant had intentionally signed up for a one-year period of self-exclusion and therefore could not seek removal until at least that much time had elapsed. In its September 12, 2025 letter, the division advised appellant of his right to appeal and copied the commission as required by NJAC 19:42A-4.1c. No hearing was held by the division. Appellant filed the instant appeal on or about October 2nd, 2025. Oral argument was held on November 21st, 2025, at which time the record was closed. I was the hearing examiner. Based upon a thorough consideration of the record, which is de novo, pursuant to NJAC 19:42A-5.5, I conclude that appellant failed to demonstrate that he did not place himself on the SEL as required by NJAC 13:69G-2.2C. That is the December 31st, 2025 initial decision under the statement of the case and procedural history. Now, on January 13th, the division sent this agency a correspondence entitled Clarifications for the Record. The division listed two issues for clarification. One, the division notes that in the initial decision's findings of facts on page 2 of the opinion, it erroneously reads, and I'll quote, appellant lives in New Jersey and is retired. The testimony and evidence revealed that on August 14th, 2024, appellant decided to create an account with BetMGM. After reviewing the documents of the appellate record, it became apparent to me that the second sentence that states appellant created his account with BetMGM on August 14th, 2024 is indeed an error, and I thank the division for pointing that out. According to the documents of the appellate record, the appellant created that account with BetMGM on January 8th, 2025. Now, the second issue of clarification, if you will, as contained in the division's correspondence, first of January 13th, 2026 states, and I'll quote it in its entirety. Second, subsequent to the hearing, it was ascertained that on August 24th, 2025, appellant had enrolled in an additional one-year self-exclusion term through the division's online portal. while appellant testified during the hearing that he did not intend to self-exclude while on the BetMGM platform and argued that he should be removed from the self-exclusion list early, he did not disclose this subsequent enrollment. Appellant's own actions demonstrate that he voluntarily signed up for another term of self-exclusion prior to the hearing, which renders his argument of accidental enrollment moot. Somewhat strong assertion. So when I read that, I had a couple questions, and I conferred with Senior Counsel Pimpinelli, who then sent the division an email on January 22nd, which asked, how and when did the division learn of appellant's placement on SEL on 8/24/25? And how was appellant able to place himself on the SEL on 8/24/25 if he was already on the SEL? Now, with regard to question number one, how and when did the division learn of appellant's placement on SEL on 8/24/25? The division, via that same email of January 23rd, 2026, answered, and I quote, "The division learned of appellant's August 24th, 2025 placement on the self-exclusion list during the course of its ongoing reviews in the performance of its statutory duties. As a result thereof, and based on the following detail, this case is now moot." Now, that's a little bit stronger than what the division said in its January 13th correspondence, when it basically said that JM's argument was moot. With regard to question number two, how is appellant able to place himself on the SEL on 8/24/25 if appellant was already on the SEL? Again, that's Senior Counsel Pimpinelli's question. The division answered that the self-exclusion system allows a patron already on self-exclusion list to enroll for an additional term. Now, in the middle of all this, I did my own independent research and found that according to the division's website, a person who's self-excluded at some point can indeed extend the self-exclusion at some time subsequent to the first exclusion. I'm just not sure, and it's not for our discussion today, that can be done through the portal. I thought the person had to come in person. But be that as it may for now. Okay. So as best I can discern, I'm almost done, I promise. The division's January 13th, 2026 correspondence seeks to have the commission clarify its initial decision by acknowledging that JM's subsequent placement on the self-exclusion list on August 24th, 2025 renders his argument at the appeal hearing that he accidentally placed himself on the exclusion list on January 8th moot. That's what the letter said. Here's what the email said. The email appears to request that in addition to that, or by amplification, if you will, the initial decision should clarify that by acknowledging that because JM later placed himself on the self-exclusion list on August 24th, 2025, the case is now moot. That's what was written in the email. Mr. Reed, is that about right?
Yes, sir.
Okay, let me tell you why I can't do that. To begin with, based on my experience in litigating hundreds of appeals in both state and federal court, an appellate decision is grounded solely on the testimony, evidence, and record presented to the appellate judge or panel at the time of the appeal. It can't be clarified or changed in any way by evidence outside the record, certainly not evidence derived subsequent to the record. So on the date of this appeal hearing, November 21st, 2025, there was no evidence before me indicating that JM had again placed himself on the self-exclusion list on August 24th. In fact, I still have no evidence. The only thing I got is the assertions contained in the correspondence and the email. But put aside my personal experience in my former career, let me read what the New Jersey Administrative Code tells us about the record on appeal. NJAC 19:42A-4.3 says, and I quote, "The record on appeal shall include all papers, exhibits, including audio and video recordings on file with the division, together with the entries as to matters on the record, subsection 1, within 20 days of the service upon it of a notice of appeal, the division shall file a statement with the commission of the items comprising the record on appeal. Caveat, subsection C says, if any time during the pendency of the appeal, it appears that evidence not adduced in the proceedings before the division may be material, on the motion of any party, including the division, the record may be supplemented by taking additional evidence and the making of a finding of fact thereon by the division. So, for the purposes on appeal, that's the record on appeal for our purpose that I had before me. Items sent to the commission by the division within 20 days of the service of a notice of appeal from JM, and there was no other item sent to me by motion by the division during the pendency of the appeal. And the pendency of the appeal in the JM matter ended when the record closed after the hearing I did on November 21st, 2025. So, because at no time within the 20 days of JM's notice of appeal, or by motion to supplement the record during the pendency of the appeal, no evidence was ever provided by the division to me to support the January 2026 assertion in the correspondence in the email that JM had self-excluded again. That assertion is not part of the appellate record, simply. And if it wasn't part of the appellate record, I can't clarify the initial decision on something that wasn't part of the record. So I can't do that. All right. So I'm going to make a motion. Here's the motion. At this time, I move to modify the initial decision only to reflect that the date on page 2 should be January 8th, 2025, not August 14th, 2024. That was my mistake. And adopt the initial decision as modified pursuant to NJAC 1:1-18.6, and find that the appellant failed to demonstrate that he did not intentionally place himself on the division's self-exclusion list as required by NJAC 13:69G-2.2C, and deny his request to be removed from the division's self-exclusion list prior to his January 8th, 2026 expiration date. That's all I got.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
Hearing none, all in favor say aye.
Aye.
Aye, opposed, ayes have it.
Thank you.
Item number 12 is consideration of the Division of Gaming Enforcement's motion in the matter of the State of New Jersey versus Kyledia Macon, and that's docket number 230048RC, and in the matter of the initial application of Kyledia Macon for a casino key employee license. That is docket number 260011OT. Again, we have Senior Counsel Pimpinelli to address that with you.
Chairman and Commissioners, Teresa Pimpinelli, Senior Counsel, appearing for the Commission. For my final matter before you today is consideration of a motion filed by the Division of Gaming Enforcement seeking a ruling from the Commission to return the pending contested case for an initial application of Kyledia Macon for casino key employee license back to the Division for additional investigation. Ms. Macon was notified of today's proceedings. I would ask counsel for the Division to enter their appearance and proceed.
Chairman and Commissioners, Jocelyn Fedowitz, Deputy Attorney General, on behalf of the Division of Gaming Enforcement. The division filed a report dated August 25th, 2023, recommending the denial of the application of Kyledia Macon's application for casino key employee licensure due to the applicant incurring a disqualifying criminal charge, which was pending at the time, as well as a noted financial issue. The matter was remanded to the contested case process and placed in deferral status pending the adjudication of the pending criminal matter. The criminal matter has since been resolved, and consequently, the division will need to conduct its own investigation of the alleged conduct which led to the criminal charge in order to conduct a full and complete investigation of the applicant's qualifications for casino key employee licensure. Accordingly, the division requests that this matter be transferred from the contested case process and referred back to the investigative process with the division so that a thorough investigation can be completed and the relevant issues can be established for the division's recommendation to the commission. Thank you.
And for the record, the applicant is not here.
Correct.
Thank you. Are there any questions regarding this matter?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I have reviewed Senior Counsel Pimpinelli's memo, the division's reports, the additional documentation they sent in, including documentation indicating a dismissal of underlying criminal charges. And at this time, I move to grant the requested relief, order that the initial application of Kyledia Macon for a casino key employee license be transferred back to the Division of Gaming Enforcement in order to fully complete its investigation.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, all in favor say aye. Aye. Opposed? Ayes have it.
Item number 13 is consideration of the initial decision in the matter of the initial casino key employee licensure of Travis Tong Trung, docket number 250198CK. This matter is furtherance of the initial licensure of Mr. Trong in following up the division's plenary report of October 2, 2025. Mr. Trong's temporary license was extended through to today's date to facilitate the matter being remanded to the contested case process. The hearing was conducted on December 18, 2025 by hearing examiner Commissioner Formica. The initial decision was filed and released to the parties on January 30, 2026. I will note for the record that both the division and counsel for Mr. Trong released the time period, waived the time period to allow for them to file exceptions in order to facilitate this matter being considered by the commission today. You have counsel for the division present, as well as counsel for Mr. Trong, and I ask that they enter their appearances and address the commission directly.
Morning, Chairman and Commissioners. Lucas Leviton, Cooper Leviton Law Firm, on behalf of Travis Trong. Mr. Trong is here with me as well.
Morning.
Morning. Thank you.
Good morning, Chairman and Commissioners. Tracy Richardson, Deputy Attorney General for the Division of Gaming Enforcement.
Morning.
Commissioners, we respectfully ask that you adopt the initial decision as written by Commissioner Formica in full, finding that Mr. Trong be found plenary qualified to hold a casino key employee license dated January 30th, 2026. Thank you very much. I apologize for my voice.
No.
We all got frogs. I have a frog in my throat today, too.
Commissioner Formica's initial decision is in accord with the plenary report that the division had filed with you dated October 2nd, 2025, recommending the plenary casino key employee licensure and qualification for Mr. Trong. And also, as addressed by General Counsel Fauntleroy, we waived the time period for filing exceptions and did not file any exceptions to that decision. Thank you.
Thank you.
Any questions for counsel?
No, sir.
I have a question for Mr. Levison. I actually thought that your father would be here today, but he sent you, so you can refer this back to him if you cannot answer it. I'm supporting my colleague on what he on his questionnaire of what he did with Mr. Trong. But good morning. And as I was reading my colleagues giving a thorough questionnaire, I have a question that needs to be cleared up in my mind, which Mr. Levison noted previously in his first presentation in reference to the history book. And I do not fully understand why, and I think it was totally unnecessary for me to have to read the book that he presented in his presentation. I'm referring to page 329 of the Household Headship in Red River Delta, Vietnam. The reason why I said this is because Reason why I think it was totally unnecessary is since in the United States, black households have also similar, things that go on in their household where they take charge of everything that goes on in their household, especially the women do. So when I read this, and I did have to take time to read about Vietnam, I remember the stories of it years ago, what had happened in the United States and Vietnam. So I want to understand why that book was necessary for that reference of this presentation. And maybe your father can answer it, if you can't. Actually, I thought he would be here today.
Well, respectfully, myself and the commissioners may not have been fully immersed in what Vietnamese culture is, as far as the matters set forth in here, which was referring to lucky numbers, it was referring to head of households, and those are things that, you know, none of us lived. You know, you compared it to a black household. You have lived that. We don't know. So we attempted to provide supporting information that was not just look it up on the internet, or that would support the notion that the idea of supporting his family, that, you know, on paper, if I could, you know, some of the material with he taking financial responsibility for assets for his family. Neither of Mr. Truong's parents are present anymore, and he has maintained that responsibility, and it aligns with Vietnamese culture and things in that book. So that was the reason for it. We felt it was a good added material rather than, I don't have many friends or colleagues that are Vietnamese that I could, you know, interview and get a professional opinion of. So that's the source that we selected.
Thank you.
Any other questions for council?
No, sir.
Hearing none, is there a motion?
Yes, Mr. Chairman, thank you. As you know, I was the hearing examiner for the contested case hearing in this matter, during which time I had the opportunity to review the division's investigative reports, applicant Travis Truong's submissions, the arguments, if you will, of counsel, Mr. Levinson and Ms. Richardson, and of course, I also heard the live testimony of Mr. Truong himself. And after a review of the complete and detailed record, I also went over the hearing transcripts before we wrote the opinion. So for the reasons and conclusions expressed in the initial decision, I move to adopt the initial decision pursuant to NJAC 1:1-18.6, grant an initial casino key employee license to Travis Truong, find Mr. Truong qualified to serve as Vice President, Asian Marketing for Marina District Development Company, LLC, doing business as Borgata.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, roll call vote?
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Thank you.
Congratulations.
Thank you.
Thank you very much.
Item number 14 is consideration of the plenary qualification of Albert L. Faulkner to serve as a director of Pioneer Fiduciary Company, LLC. This matter was initiated by a petition PRN 157-2501 dated June 6, 2025 by AC Ocean Walk, which sought Mr. Faulkner's temporary qualification as indicated to serve as a director of Pioneer Fiduciary Company, which is a qualified entity qualifier and security holder for the casino licensee. You granted Mr. Forkner temporary qualification at your July 2, 2025 public meeting and memorialized that action in Resolution 25070212. Before you now is Mr. Forkner's plenary qualification, and you have counsel for the casino licensee as well as counsel for the division present, and I ask that they enter their appearances and direct the matter to your attention.
Good morning, Chair, new Vice Chair, and Commissioner. I will take a moment to address the Vice Chair and wanted to say, having been on the receiving end of some of your incisive questions over the years, I can attest that not only have you educated the newest commissioner, but you've educated those who appear before you. You know, certainly I could only speak for myself, but I'm sure it's not just me. Not only making us better attorneys for our casinos, but broadening our perspective and making us better representatives of the community and its residents and the people we serve. So I do thank you for doing a really good job. As Ms. Fauntleroy stated, Mr. Faulkner was temporarily qualified to assume the duties and exercise the powers of a director of Pioneer Fiduciary Company prior to plenary qualification. He was being plenarily qualified because he is a director of a holding company of AC Ocean Walk, as a trustee of entities having a 50% indirect ownership in AC Ocean Walk. The division issued its letter, report, and recommendation, and we respectfully request you grant the relief, and we've reviewed the resolution and have no objections. Thank you.
Good morning, Chairman and Commissioners. Ellen Fertagos, Deputy Attorney General for the Division of Gaming Enforcement. The division filed its report dated January 23rd, recommending the plenary qualification of Mr. Forkner. We've also reviewed the draft resolution, addressed a typographical change, and find it acceptable. Thank you.
Are there any questions for council?
No.
Hearing none, is there a motion?
Mr. Chairman, can I just correct my record? I ascribed their qualification status to Pioneer that belongs to MGA. They are a holding company
It shows I wasn't listening.
as Council Kaufman indicated, they are a holding company, a qualified holding company of AC Ocean, not an entity qualifier security holder. I'll repeat that in a few minutes.
Hold that thought.
Hold that thought. I just wanted to clarify the record. Thank you.
Thank you.
Is there a motion then?
Yes, sir. Thank you, Mr. Chairman. I reviewed the memo of General Counsel, the division's reporting in this matter. I reviewed the draft resolution. At this time, I move to adopt the draft resolution, find Albert L. Forkner qualified to serve as Director of Pioneer Fiduciary Company, LLC, in accordance with NJSA 5:12-85.1 and NJAC 13:69C-2.7.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
Sir.
Hearing none, roll call vote.
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Item number
Thank you.
15.
Thank you.
Thank you.
Item number 15 is the joint petition of Marina District Development Company, LLC, doing business as Borgata Hotel, Casino, and Spa, and MGM Resorts International, requesting permission for Karen M. Wells to assume the duties and exercise the powers as a member of MGM Resorts International's Compliance Committee, pending plenary qualification. That is PRN 0272601, which was by petition that was dated January 27, 2026, by its holding company, MGM Resorts of Borgata. You have before you, I believe counsel for MGM is via Zoom. CJ Fisher and counsel for the division is present. And with your permission, Mr. Chairman, I ask that they enter their appearances and proceed.
Good morning, Chairman and members of the commission, and congratulations as well to the new Vice Chair. CJ Fisher, partner with Fox Rothschild, appearing on behalf of the joint petitioners, Marina District Development Company LLC, doing business as Borgata Hotel, Casino, and Spa, and MGM Resorts International.
Thank you.
Morning.
Good morning again, Chairman and Commissioners. Tracy Richardson, Deputy Attorney General for the Division of Gaming Enforcement.
Morning.
Commissioners, before you is Borgata's and MGM's joint petition requesting the temporary qualification of Karen Wells to assume the duties and exercise the powers of a member of the Compliance Committee for MGM Resorts International. I have reviewed the draft resolution and have no objections to its form or substance, and respectfully request that the commission approve the resolution and grant temporary qualification to Ms. Wells. Thank you.
The division filed with the commission a letter of no objection dated February 3rd that does not oppose any temporary qualification for Karen Wells. We've also reviewed the draft resolution and have no objections. Thank you.
Are there any questions for council?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I reviewed the joint petition, general counsel's memo, the division's report, voicing no objection, reviewed the draft resolution, and at this time I move to adopt the draft resolution and authorize Karen M. Wells on a temporary basis and prior to her plenary qualification to assume the duties and exercise the powers as a member of the Compliance Committee for MGM Resorts International, subject to the conditions contained in NJSA 5:12-85.1C and NJAC 13:69C-2.7.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, roll call vote?
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Thank you.
Thank you.
Thank you.
Mr. Chairman, with your permission, can I jump to item 17?
Yes.
Since that's the last council matter. That is the joint petition of DGMB Casino LLC, doing business as Resorts Atlantic City, and MGA Holding NJ LLC, requesting permission for Joseph Hassoun to assume the duties and exercise the powers of manager and president of MGA Holding NJ LLC pending plenary qualification. This matter was initiated by a petition dated January 9, 2026, PRN 01-22601, seeking as indicated the temporary qualification of Mr. Hassoun to serve as the manager and president of MGA Holding NJ LLC, which is an entity qualifier and security, qualified entity qualifier and security holder of DGMB LLC, the casino licensee. Counsel for both parties are present, and with your permission, Mr. Chairman, I ask that they enter their appearances and proceed directly.
Good morning again, Chair, Vice Chair, Commissioner, Lynn Kaufman, Cooper Levinson, on behalf of DGMB Casino and I have a voice thing too, MGA Holding NJ LLC, who is a 10% indirect security holder and entity qualifier of DGMB Casino, which is Resorts. As stated, a petition for temporary qualification for Mr., and I'm not sure if it's Hassan or Hassan, was filed, seeking temporary qualification to assume the duties and exercise the powers of manager and president of MGA Holding NJ LLC prior to plenary qualification. We're appearing before you today to request the relief, grant the relief that was requested in the petition. We have reviewed the draft resolution and have no objection. Thank you.
Chairman and Commissioners, Jocelyn Fedowitz, Deputy Attorney General, on behalf of the Division of Gaming Enforcement. The division filed a letter response dated February 4th, 2026, of no objection to the request for temporary qualification of Joseph Hassan. Additionally, the division reviewed the draft resolution and has no objections. Thank you.
Are there any questions for council?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I reviewed the petition, the memorandum of general counsel, the division's correspondence indicating no objection, and the draft resolution. And at this time, I move to adopt the draft resolution and authorize Joseph Hassan on a temporary basis and prior to his plenary qualification to assume the duties and exercise the powers of manager and president for MGA Holding, NJ, LLC, subject to the conditions contained in NJSA 5:12-85.1C and NJAC 13:69C-2.7.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, roll call vote.
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Thank you.
Thank you.
Thank you.
I think the tropical temperatures going from, teen to 40 is
Everybody's voice, yeah.
messing with everybody's voice, yes. Mr. Chairman, we return to item number 16, which are delegations of authority to commission chairman and commission staff. We have four delegations. The first delegation, there are amendments to the chairman's delegation, which include adding the multi-casino endorsement request for qualifiers, the ability to do that on a temporary or plenary basis, only if the individual has already been found qualified by the commission and under extraordinary circumstances, and there are time limitations. The second change is to allow for the change of a title of a previously qualified person, provided time is of the essence. It is recommended that the chairman's delegation of authority as amended be adopted.
Are there any questions for council?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I've reviewed the draft resolutions and the historical attachments, and I move to adopt as amended the resolution delegating authority to perform certain functions to the chairman as explained by general counsel.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No,
No.
sir.
Hearing none, roll call vote.
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
The second set of delegations are for the general counsel and the executive secretary. Neither are changed. The general counsel's delegation is to permit redactions of Division of Gaming Enforcement reports in casino licensing matters and otherwise. And the executive secretary's delegation allows for review and approval of outside employment requests and cohabitation waivers, which ultimately must be approved by State Ethics Commission. It is recommended that both delegations be readopted unchanged.
Are there any questions for council?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I reviewed the previous resolution. At this time, I move to readopt the resolutions delegating authority to perform certain functions to the general counsel and the executive secretary.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, roll call vote.
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
The last delegation is to the Director of Regulatory Affairs. The amendment of that delegation permits the withdrawal of temporary and/or plenary casino key employee license applications that include negative information from the division only upon consultation with the chairman and a determination made by the chairman as to whether the action will be performed by delegation or put before the full commission for its action. With that amendment to that delegation, it is recommended that the delegation be adopted.
Are there any questions for council?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I reviewed the amended resolution, and I move to adopt as amended the resolution delegating authority to perform certain functions to the Director of Regulatory Affairs as explained by General Counsel.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
sir.
No.
Hearing none, roll call vote.
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
In accordance with Resolution 25121003, the next closed session will be held on Wednesday, March 11, 2026, at 9:30 a.m. in the Commission offices.
This is the public participation portion of the meeting. Is there anyone from the public that wishes to speak? Ms. Fauntleroy, do we have any email comments?
I have been advised that we do not, Mr. Chairman.
The public participation portion is now closed. Is there a motion to adjourn?
Yes, sir. Thank you, Mr. Chairman. I make a motion to adjourn today's public meeting.
Do we have a second?
Mr. Chairman, I second the motion.
All in favor, say aye.
Aye.
Aye, opposed, ayes have it. Meeting is now adjourned. Thank you.
Thank you.